legal advisors during the Civil War, and Lieber's definition of insurrection appears in Lincoln's General Order number 100 to the Union Army. And Professor Maglioka says that Lieber was, I don't have his transcript before me, but in effect, the leading legal scholar of his period. And Lieber actually taught at Columbia, which I'm proud of. And in General Orders number 1, which I have studied and taught about for quite a while, Lieber says, again, I don't have the text right in front of me, but he says, in effect, an insurrection is the rising of the people in arms. So if you accept Lieber's definition as definitive, or at least very weighty evidence of the meaning of insurrection.
Si vamos a aceptar esta definición como el significado de una insurrección tendría que ser armada. Las insurrecciones tendrían que ser armadas. Y esto concuerda con muchas, si no todas, pero sí con muchas otras definiciones, incluyendo la jurisprudencia que cita el profesor Maglioka. Así que hay algunas contradicciones, quizás sea demasiado fuerte, pero hay ciertas tensiones entre las concepciones de insurrección que contemplan algunas fuentes, entre la definición de Bliebers y la insurrección armada. El profesor también cita la definición de insurrección en el diccionario Webster en 1928. ¿Recuerda eso? Sí, leí la cita. Sí. Y aquí dice, es el levantamiento contra la autoridad cívica o política en oposición activa a la ejecución de la ley en una ciudad o un estado. Y también cita la definición de insurrección según John Bogue, idéntica a la definición de Webster. ¿Cómo interpreta eso usted? Bueno, la definición de Webster específicamente se refiere, como usted cita, a estados y condados. Obviamente es relevante ese significado de insurrección en la sección 3. No es idéntica porque en la sección 3 la insurrección se contempla como en contra de la Constitución de los Estados Unidos, que no es un estado o un condado. Disculpe, su señoría. Estados Unidos no es un estado o un condado. Y cuando usted habla de insurrección contra la Constitución de los Estados Unidos, ¿cuál es la importancia de esa distinción? Creo que esto es crucial porque, si bien ayuda mucho el saber cómo se entendía el concepto de insurrección desde 1866 a 1868, ciertamente es muy útil. El profesor Maglioka mismo enfatiza que hay un importante principio limitante que está en el texto de la sección 3. No es una insurrección simple, es una insurrección contra la Constitución de los Estados Unidos. Eso está en el texto y es un elemento crucial de este punto, que la insurrección sea contra la Constitución de los Estados Unidos. En otras palabras, insurrección no es un término con peso propio, sino que está aparejado a lo que el profesor Maglioka menciona. Esto está aparejado a otra frase, insurrección contra la Constitución. Así que lo que se decide acá no es tan simple, como digo, un significado simple de insurrección, sino toda la concepción de una insurrección contra la Constitución de los Estados Unidos. En mi opinión, aunque yo sepa, no hay una definición legal de esa frase. El profesor Magliuca también contra la Constitución en la sección 3. Él ofrece su propia interpretación. Es la interpretación de una insurrección contra la Constitución, lo que esto significa. Y él dice que bajo su interpretación de esa cláusula constitucional, estas no son insurrecciones contra la Constitución de los Estados Unidos. Creo que eso depende del significado, la acepción de insurrección contra los Estados Unidos. Y puede haber interpretaciones más o menos amplias de ese concepto, de lo que esto significa en términos de estas insurrecciones contra la Constitución de los Estados Unidos. ¿Y cuál sería esa lectura? El profesor Magliocca ofrece esta interpretación. Una insurrección contra la Constitución de los Estados Unidos es una que interfiere con la ejecución de la Constitución. Y la interrogante es entonces, bueno, ¿cuál es la ejecución de la Constitución? Y en esencia entiendo que cuando mencionan la ejecución de la Constitución, es interferencia con las ramas políticas y judiciales del gobierno federal en el desempeño de sus funciones constitucionales. Si hay una interferencia con el descargo de sus responsabilidades constitucionales. Y él aduce que los eventos del 6 de enero constituyen una interferencia con una responsabilidad asignada al Congreso en la 12ª enmienda, cuando menos de validar el conteo de votos. Por definición, esto sería una interferencia con una función constitucional y creo que puede haber otros acontecimientos que se pueden considerar insurrecciones contra la Constitución, aún en el sentido de ejecutar disposiciones constitucionales. Por ejemplo, si hay una interferencia con la ejecución de funciones judiciales, la decisión de casos, obviamente una responsabilidad del Poder Judicial bajo el artículo 3. Si hay una interferencia con las responsabilidades judiciales, eso también sería lo mismo. Alterar un proceso judicial bajo ese concepto de la Constitución, eso también pudiera considerarse una insurrección contra la Constitución o contra la aplicación de la Constitución, o en otro concepto, la Constitución le confiere al senador el papel de decidir o debatir nombramientos presidenciales, nombramientos, por ejemplo, para el Poder Judicial federal. Si uno tiene una turba perturbando el voto en el Senado sobre un nombramiento presidencial, eso pudiera considerarse una interferencia con la ejecución de una función constitucional. Y bajo esa premisa, bajo esa definición, interferir con la ejecución de la Constitución e incluso interrumpir la distribución del correo se consideraría como una interrupción con una función de la Constitución, porque el presidente tiene la obligación constitucional de garantizar que las leyes federales se cumplen fielmente. Así que si se interfiere con la ejecución de las obligaciones constitucionales del presidente en el ámbito postal. ¿Y por qué habla del servicio postal? Bueno, porque el artículo 1 menciona el servicio postal y es una obligación del Congreso el ejercer este poder de crear y de instruir al presidente para que administre el estatuto del servicio postal. Para ir al grano, diría que incluso bajo la interpretación del profesor Magliocas, incluso la interrupción de la distribución del correo se puede considerar una interrupción de la Constitución, una interferencia. Y uno pudiera seguir con interferencia en el descargo de las obligaciones del presidente, del Senado, de la Cámara, de representantes, de los tribunales. Todo eso pudiera interpretarse como una acción en contra de la Constitución. Así que el concepto es sumamente amplio, a menos que se tenga una perspectiva más limitada sobre lo que se debe leer como contra la Constitución. Esto cubre muchas cosas en cuanto a lo que es y lo que se puede considerar insurrección. Entonces, esa definición también incluye intimidación, ¿correcto? O acciones intimidatorias o la amenaza de violencia. No entiendo la pregunta. Permítame pasar a un área ligeramente diferente. Por lo que entiendo que usted dice, es que si tomamos la definición del profesor Magliocas de que es una insurrección, pudiera decirse que hay una letanía de casos. Sí, prácticamente todas las interferencias con las funciones del presidente, el Senado, la Cámara de Representantes o el Poder Judicial Federal. Y cómo debería ser. Ese es el límite hasta donde sea posible. Déjeme preguntarle lo siguiente. El profesor Magliocas también testificó que existía lenguaje de insurrección y que esto, incluso las palabras de incitación, pudieran considerarse incluidas si él se basa en una opinión del Poder Judicial. ¿Cuál es su opinión al respecto sobre el uso de esta opinión para definir lo que es una insurrección? Bueno, hay tres cosas que pudiera decir al respecto de lo que dice el profesor Magliocas en su testimonio y en su reporte. Primero que nada, diría que hay un punto lingüístico aquí. Creo que hacer una actividad de insurrección tiene distintos significados. Estos son las variantes del idioma inglés. Déjeme explicarle. Si nosotros hablamos, por ejemplo, de hostilidades, probablemente tendríamos que considerar acciones de combate, no las acciones preparatorias de lo que se pueden considerar hostilidades. Podemos hacer una distinción entre hostilidades e incitación. Este es un punto lingüístico. Pero el trasfondo constitucional en la sección 3 se habla de actividad de insurrección, y parte de esto es el acta de confiscación que creo que cita el profesor Magliocas, que per se hace una distinción entre distintas acciones preparatorias de una insurrección o una rebelión y la rebelión en sí. Ese es el lenguaje de la segunda acta de confiscación. Así que aquí se hace una distinción entre lo que sería incitar una rebelión contra una insurrección en sí. Aquí no se incluye o se excluye otros aspectos del lenguaje, y en la sección 3 se lo restringe a una actividad de insurrección donde se sugiere que no se cubre el mismo tipo de actividades que en la segunda ley de confiscación. Así que la insurrección en la sección 3 tiene una definición más estricta sobre las actividades asociadas con una insurrección que usted ve mencionadas en la segunda ley de confiscación. Yo concuerdo con el profesor Magliocas en que estas interpretaciones, estos estatutos y su interpretación en la ley de reconstrucción de 1867, yo concuerdo con él en su opinión sobre esta materia, y ciertamente hay buena evidencia respecto a lo que es una insurrección bajo la sección 3. Aquí hay opiniones sobre la sección 3 que se pueden debatir y se debatieron en el proceso de ratificación, y esencialmente aquí hay una sección en la primera de sus opiniones sobre el lenguaje estatutario de lo que significa ser parte de una insurrección. Esto lo dicen sobre los estatutos, pero se dice que el abrazar una actividad de insurrección es eso, para fines y propósitos. Viendo la opinión de Stansbury, ¿cuál es su posición respecto a la forma en que él define la insurrección y su aplicación a la 14ª enmienda, sección 3? Creo que el profesor Magliocca describe lo que escribe el secretario de Justicia sobre esta materia en la primera de dos opiniones en la ley de reconstrucción militar. En el primer caso, Stansbury tiene una sección donde habla de participar en actos de insurrección o rebelión. se trata de ser parte de una insurrección. Él dice, por ejemplo, esto es lo que él interpreta del estatuto. Él comienza diciendo que hay que distinguir entre una participación activa o pasiva en una rebelión. Primordialmente se refiere a lo que es una rebelión, no una insurrección. Así que habría que comenzar distinguiendo lo que es una participación activa o pasiva. Una participación pasiva en una rebelión no cuenta bajo el estatuto. Esa es su primera distinción. Después, él dice que hay que hacer una distinción entre la actuación voluntaria o compulsiva. No toda la participación tiene que ser activa, pero sí tiene que ser voluntaria. Si alguien es coaccionado para que ayude en una rebelión, eso no lo enmarca dentro de los confines del estatuto. Así que hay una distinción, el aspecto pasivo. Y después él tiene una tercera distinción entre la participación en una capacidad oficial y la participación a título individual. Y él tiene una extensa discusión respecto a la participación de un funcionario activa y voluntaria. Es el caso, por ejemplo, de el embajador ante Francia de los Estados Confederados. Esa no es una posición de combate, claramente. Pero también hay una discusión sobre lo que significa participar en una rebelión a título individual. Así que hay que entender el estatuto bajo una óptica. Si estamos hablando de una insurrección, si alguien está actuando en capacidad oficial o si alguien está actuando a título individual. Así que para volver al marco del estatuto, si alguien está actuando a título individual, se requieren criterios adicionales en contraste con una actuación oficial. Hablemos, por ejemplo, del caso del presidente Trump. Si usted analiza la interpretación de Stanbury, vamos a objetar cualquier opinión sobre lo que el presidente Trump hubiera hecho o no. Eso se sale del alcance. Déjeme preguntarle sobre la definición de Stansbury. ¿Puede repetirla? Usted se refiere al estatuto. Me refiero a la ley de reconstrucción militar, Stansbury. Sí. También se conoce como la ley de reconstrucción. Creo que es la acepción más común. Usted dice que Stansbury estaba opinando sobre rebelión primordialmente. ¿Puede usted hablarnos un poco más acerca de las diferencias en su análisis de rebelión versus insurrección y cómo se puede aplicar esto a la sección 3 de la 14ª enmienda? La mayor parte de la discusión en esta opinión del caso se refiere a lo que significa participar en una rebelión. ¿Por qué es importante esto? Bueno, no es el punto de participar en una insurrección, pero ciertamente arroja luz sobre esta materia, pero directamente no se refiere a ser parte de una insurrección bajo el estatuto. Ciertamente ayuda, pero para ir al punto, no estoy seguro que todo lo que dice Stansbury en relación con una rebelión se puede extrapolar automáticamente a participar en una insurrección en cuanto al significado de una insurrección. Estos son distintos pasos en el proceso y si alguien hiciera esto, eso habría que determinar si lo hizo en capacidad oficial o individual. Así que habría que preguntar si su actuación fue en capacidad oficial o a título individual, lo cual sería problemático para dirimir legalmente. ¿Y por qué? Hasta donde sea posible determinar cómo se puede aplicar la opinión de Stansbury a las actividades de una persona a título individual o en capacidad oficial. Bueno, esto es un territorio inexplorado, pero no todo lo que dice el profesor Maglioka sobre Stansbury, él cita, pero no todo esto se traduce inmediatamente a cada caso individual. Habría que decidir si el lenguaje que él está citando de participar en una rebelión en capacidad oficial también es aplicable cuando alguien participa en una rebelión a título individual. De acuerdo con Stansbury, habría que establecer esta distinción primordialmente. Si la persona está actuando a título individual y si eso cuenta, si se llenan todos los criterios de lo que sería una rebelión en una actuación bajo condición oficial y si esto se puede proyectar a una actuación a título individual. Esto es bastante difícil per se y más aún el definir todo lo que él quiere decir bajo la sección 3. Stansbury da alguna guía respecto a exactamente qué significa este tipo de obligación para acciones a título individual en lo que considera una rebelión. No, creo que él no llega a ese punto, no al menos en esta parte. Él no habla de la responsabilidad. Él ofrece ejemplos más que estándares de cómo aplicar los estatutos, pero no habla del nivel de obligación, al menos no en esa parte. Él no habla de el nivel de responsabilidad de alguien acusado de insurrección. Y él dice exactamente cómo se puede determinar si una persona ha sido parte de una rebelión actuando a título individual. Él discute ese punto. No recuerdo exactamente el lenguaje, pero si nos concentramos en esa parte de la opinión de Stansbury, hay que hacer la definición de si alguien está actuando a título individual o bajo condición oficial. Hay que determinar cómo la persona se hizo parte de una rebelión a título individual. No tengo el lenguaje directamente a la mano. El profesor Maglioka también compara la opinión de Stansbury con el caso Worthy de Carolina del Norte. Y él dice que esta es la definición de actuar en una insurrección, que es la misma. La opinión de Stansbury en este caso de Carolina del Norte. ¿Cuál es su opinión? Bueno, Stansbury está hablando en términos estatutarios. En la opinión sobre Carolina del Norte, de lo que está hablando en la sección 3. Háblame del caso Worthy. Cuando dice la sección 3, es un caso de Carolina del Norte. Sí. Y esto se decidió bajo un estatuto estatal que incorpora la sección 3 por referencia y lo hace operativo para el caso de Carolina del Norte. Al menos bajo ese concepto se refiere a funcionarios estatales y no federales. Entonces, creo que no es relevante para entender lo que significa ser parte de una rebelión o una insurrección bajo la sección 3 de la Constitución. Bueno, no es idéntico a lo que ofrece Stanbury, pero es más relevante para la pregunta de si la sección 3 es ejecutable. Pero no va más allá. Hablaremos de eso en un minuto, pero en su opinión, las definiciones respecto a lo que es participar en una rebelión difiere entre la óptica de Stanbury y el caso Worthy. Diría que no. Discúlpeme, si puedo tener un poco más de agua. Usted ha hablado un poco acerca de la insurrección contra la Constitución como se aplica en la sección 3. Correcto. Permítame preguntarle lo siguiente. ¿Hasta qué punto las fuentes históricas nos permiten crear una definición específica de insurrección contra la Constitución? Bueno, no estoy al tanto de ninguna discusión en el Congreso o en los debates de ratificación sobre ese principio limitante. Entonces, usted vio el enfoque del profesor Maglioka sobre la limitación de la Constitución. ¿Puede usted crear una definición de insurrección contra la Constitución en base a documentos históricos? Bueno, le diría lo siguiente. Yo me guiaría más por lo que dijo el senador Jacob Howard cuando le presentó al Senado la 14ª enmienda. En esas expresiones del senador que se citan 2 veces en el reporte de Magliokas. No tengo el lenguaje exacto que usó el senador Howard, pero Howard dice algo en el sentido de que al menos esta sección de la Constitución tiene la finalidad de cubrir acciones sancionadas y actos que no tengo el lenguaje exacto, pero básicamente que constituyen una amenaza. Me ayudaría si lo tuviera conmigo. Vamos a buscarlo, pero esencialmente el término que él usa es que destruiría la Constitución. Así que considerando el papel de Howard en la adopción de la 14ª enmienda, yo comenzaría analizando las expresiones de Howard y el análisis de la frase rebelión o insurrección contra la Constitución y acciones que amenacen con destruir la Constitución. Quisiera pedir que se elimine la última respuesta porque aquí no hay ninguna definición de insurrección o rebelión contra la Constitución. Este es un testimonio completamente nuevo. No creo que él haya dicho que la sección 3 de la 14ª enmienda debe ser visto bajo esa óptica. Usted está hablando de la perspectiva del senador Howard como una analogía, pero él no dice que esa deba ser la definición. ¿Se refiere a la opinión sobre las expresiones del senador? No, su señoría. Si me da unos minutos, permítame analizar este reporte. ¿Podemos volver a eso más adelante? Podemos volver a ese punto más adelante. Profesor Delahunty, ¿por qué discutir estas expresiones del senador en este momento? Pero ¿por qué parte usted de esta base, estas declaraciones en un debate en el Congreso? Es la misma opción. No creo que le esté ofreciendo una nueva definición. Dice que sería útil poder ver esas declaraciones. Lo estamos buscando en este momento, su señoría. Puede ser que lo tengamos.
Okay.
Su señoría, vamos a necesitar dedicarle a esto algunos minutos y volvemos a este punto más adelante. En general ha sido difícil seguir el hilo de lo que he estado hablando. Podemos ver de lo que está hablando. Si pudiéramos tener un receso, eso nos daría algo de tiempo. Haremos una pausa hasta las 10:30 y regresamos.
All right, Chris. Note papers, or are they all? Chris. Sean. Oh, would you pull up? He needs to go to for Stansbury. No, I just wanted to grab a couple of pieces. He just. Thanks, appreciate it. Just talk to him right now. I don't know right now.
He's doing that.
It's difficult. So if there's anything I could just let me know.
Okay. Yeah, I gotta get my monitor.
What?
I gotta get my monitor.
Okay.
Are we moving stuff to another room?
We can move stuff to Jacob's room because he's staying over the weekend.
Let me focus on this first, okay? And let me
As long as you're coming back to the hotel, that's all I need.
let's talk about it just a little bit.
Well, I'm gonna
Oh, you are? Okay. Yeah, because I need to get my monitor.
because you need it for the weekend.
Yeah.
Okay.
I'm gonna do some work this weekend.
Aren't we all?
Yeah.
You got all your stuff out of your Okay. Okay. Don't worry about that.
Yeah, I could probably just pull it up on one of these screens for her. There.
If you're on Google Chrome, it might not work, and I can get you instructions on how to do it. Otherwise, another browser should.
I can't bring it up here. We'll see if anybody wants to try it. Google Chrome.
Preferably not Google Chrome. If not, I'll have to change one setting.
We'll just log in a different.
Session. I'm sorry. What I meant to say session. I can't log that.
I don't need to see it. Jeff wants to see it.
And it sounded like I needed to not be on that, so I'll. we have another browser, so I can just pull up another browser. I assume Edge is fine. Alright. Don't worry, it's not a real trend. There are a few hiccups, right?
I want you to get his report up that he can look at it as well. Okay?
I'm gonna have to get some hispanos on that. Okay. It's supposed to look like. Oh wow, okay. It says recesses from 10:12 a.m. to. Alright.
I don't know, just have it ready.
Alright, thanks. Well, I have it. No. Session code. Okay. Okay.
Huh? I don't know if you've tried the
Either of
just
us
in the
has.
hall and you'll take the road use agent application this session. It'll ask for a session.
Okay. No worries. Thank you.
I haven't used her to spelling. I was going to maybe ask her to spell it. Crazy to see if she can just That's the guy. If it's wrong, yeah, I can. No rush on that. I want to look at it. Okay.
If you'll get me your email, his report. You're up to your lunch for his report. Thank you.
have great phone coverage here either.
I've gotten like 3 missed calls.
Let's see how many of them are hate calls.
2.
Yeah, thank God.
You may be seated. You're back on, Mr. Gessler.
Thank you, Your Honor. Professor Delahunty, I've been asking you a little bit about talking about sort of certain case law to arrive at a definition of insurrection. But in your report, I may have been going about it the wrong way in questioning you. In your report, you talk about the difficulties of interpreting Section 3's offense element and defining what it means to have engaged in an insurrection. Do you remember that?
Yes.
Okay. And when you say interpreting Section 3's offense element, what are you referring to when you say the offense element in Section 3?
Well, Section 3 has essentially 4 elements. One of them, it's the language towards the end of Section 3, identifies the class of people who are subject to potential sanctions under Section 3. That, in my report, I called the jurisdictional element. Then there's what I've called the offense element, and here I'm following, by the way, Professors Tillman and Blackman. The offense element defines what kind of conduct by the persons jurisdictionally subject to Section 3 have engaged in that would trigger liability. And the offense element is the language to which you referred, having engaged in rebellion or insurrection against the Constitution. Then the third element is the disqualification element, which says from what offices the persons who were subject to the section and had committed the offense in question would be thereafter excluded. And then the fourth section is the amnesty provision, which empowers Congress to extend an amnesty either individually or collectively to those who were jurisdictionally subject to Section 3 and had been found to commit the offense element and would have been excluded from the relevant offices but for the amnesty if Congress chose to give them one.
Okay. So let's focus on the offense element, which you describe as engaged in insurrection. And you've looked at a number of historical sources to try and derive what that meaning is, correct?
Yeah.
Okay. And in your report, you talk about the difficulties of arriving at a conclusion, correct?
Yes.
Okay. Tell me about why you found it, or currently find it, very difficult to identify to reach a conclusion as to the offense element based on the historical sources.
Well, it's really this, that I'm not aware of any direct definition of what it means to engage in insurrection against the Constitution. I don't believe there's any case law on that. Professor Magliocco proffers his interpretation of what that phrase means. And that, as I have said and testified, is essentially to engage in interference with the to commit insurrection against the execution of the Constitution. And that, in turn, is a phrase that is opaque, I would say. And really, all of the, I don't offer my own definition of what it means to engage in insurrection against the Constitution of the United States, because, other than to gesture towards Senator Howard's remarks, because I don't know of any really good source to interpret that, which I think is not, my point is to underscore the difficulties a court would have, or really anybody would have, in interpreting that phrase, which is the crucial phrase, without such guidance, especially from Congress, which could define, under its Section 5 powers, what it means to engage in insurrection against the Constitution of the United States. Congress hasn't enacted a statute that purports to provide us with that definition. That leads me to the conclusion that the courts, as a matter of constitutional policy, should defer to Congress and not decide a case on the merits, whether or not someone had engaged in insurrection against the Constitution. There's just inadequate guidance, so far as I can tell, from the relevant sources, authorities, and so on. So this is really goes, the difficulty I experience in offering a definition, although Professor Magliocco seems more confident about it, the difficulty I experience, I think, should, if only for reasons of prudence, but really sort of constitutionally inflected reasons, lead a court to abstain from deciding what that phrase means and toss the ball over to Congress to act under Section 5.
Now, Professor Delahunty, I'm looking at our court, who I think has a inquisitorial look on her face. Your Honor, if you have a question, I'm certainly willing to defer for a moment.
I'm just trying, do you have examples of situations in which a court has basically said the Constitution's too hard for me to interpret, therefore I'm going to let Congress tell me what it means? In general, I think that that's exactly the job of the court, is to interpret the Constitution, and so I'd love to hear from you as to why you think in this instance that what I need to do is say it's too hard, Congress tell me what it means.
No, I don't have case law to cite. This really, it sort of broaches the question of whether Section 3 is self-executing or not. It goes more to that as sort of a prudential, or as I said, constitutionally inflected, separation of powers inflected reason.
Okay, so it's really the self-execution
Correct,
question.
yes.
Let me ask you this, Professor Delahunty. You looked at a number of sources in an attempt to reach a meaningful definition of engage in insurrection under Article 3, correct? And you looked at the prize cases. Do you remember that?
Not in that connection, but I do remember the prize cases, yes.
Do you think the prize cases were able to give you sort of a confidence on what the meaning of engage in insurrection
Well, they first of all, the prize cases, which is probably the most important Supreme Court case during the Civil War, prize cases do help with distinguishing between organized rebellion, and insurrection. So, of course, they're relevant in that connection in defining what insurrection means. It's certainly something to a degree less than rebellion. They're helpful in that way, but only so far. I mean, it doesn't explicate, because it wasn't in the Constitution at the time of the prize cases. The prize cases do not explicate what it means to engage in insurrection against the Constitution, because the 14th Amendment hadn't been ratified. That's not until July of 1868. So they're not helpful in that way. They are helpful in a general way in saying that an insurrection is different from a rebellion, and something sort of more high grade than a riot, but something lower than a rebellion. And insurrection, I think the court there says something like, insurrections tend, in many circumstances, to lead to rebellion, but they don't have to amount to rebellion. So it helps in that way. It's sort of suggesting a gradient between rebellion, insurrection, and other kinds of disorderly conduct.
I'm going to ask you to stay a little bit closer to the microphone when you speak, Professor. I suffer from the same challenge here.
Yeah.
And then you also looked at the charges in re charge to the grand jury. Correct. There was a particular case from 1894 from the Northern District of Illinois. Do you remember that?
Yeah, I think I do, yes.
Okay. And after looking at that, were you able to have any confidence of what engage in insurrection against the Constitution meant?
Well, I think that, no, not as to the meaning of that precise phrase. No, it helps to understand what insurrection meant, at least later in the 19th century.
Okay. And then you also looked at, in case of Davis, which was a federal judicial opinion, talking about how insurrection or rebellion may be committed by giving counsel to enemies or others raising insurrection. Do you remember that?
I don't have it before me, but
as a general matter.
Yes.
And my question really goes to all of these cases that you identified. Do they give you a sense of confidence in creating a definition of what engage in insurrection against the Constitution is?
Not really. Engage in insurrection against the Constitution, only minimally. I mean, they help you understand what engage was taken to mean, what insurrection was taken to mean.
And even from the prize cases, the most you were able to glean is that insurrection is something more than a riot and something less than a rebellion.
Yeah, that's yes, that's right.
Okay. In your view, looking at the sources and Section 3 of the 14th Amendment, and I think you've talked about this, but how does insurrection equate to insurrection against the Constitution?
No.
And why is that?
Well, self-evidently, they're different terms, and I agree with Professor Maglioka that some limiting principle should be imported into the term insurrection as used in Section 3.
So I understood your testimony before to be that the problem you have with Professor Maglioka's opinion is that he's saying an insurrection against the Constitution is essentially an insurrection against a constitutional proceeding.
Against the execution of the Constitution is what he says, and then he offers
and that those words
example of what is and what isn't such an interference with the execution of the Constitution. Yes.
Right. The words execution of Constitution aren't in there. And I guess, am I understanding what you're saying is that you don't know what insurrection against the Constitution means without adding those extra words, and that's why you think that Congress needs to decide?
Yes.
Okay.
Okay, let me mercifully move on from the subject of insurrection.
Okay.
And I'd like to talk a little bit about the doctrine of, or the application of preemption, the enforcement of Section 3 by a state court. Mm-hmm. And do you remember opining about that in your expert report?
Yes, I certainly do remember. This is one of the really crucial issues in this case and other cases. My report opined about the meaning of officer of the United States as used in Section 3. It opined about whether Section 3 is judicially enforceable either by state or federal courts without some enforcement implementing legislation from Congress, and then it opined about what it means in the constitutional sense to have engaged in insurrection against the United States and what difficulties there would be without congressional guidance in defining that term.
Okay, so we've covered the difficulties of defining insurrection. Let's talk about, well, let me ask you, we've got two more subjects I'd like to talk about. One is to whom Section 3 applies and whether it's enforceable or state or judicial, state or federal judicial courts. Let's talk about the enforcement provision, if we may. Okay? There were several instances of several actions that Professor Maglioka believed constituted enforcement. Obviously, you have a different viewpoint. Why do you believe that?
Can we start just with what exactly, what provision, what clause in the article he is referring to as the enforcement?
Okay. What's the basis for your view that Section 3 is not enforceable by state or federal courts?
Well, it could be enforceable if there were appropriate legislation under Section 5. But just standing alone, I'm not really talking about a clause because...
Let's stay a little closer to the microphone. I know you're being a professor and moving about to keep the audience engaged, but I'm going to ask you to be glued to that microphone, please.
The question is, how is Section 3 to be enforced? Can it be enforced by a court, state or federal, independently of any action by Congress, or not? There's some enforcement mechanism that Congress provides necessary for the enforcement of Section 3. Put it simply, can I just show up at a courthouse one day and ask for Section 3 to be enforced, or does there have to be some implementing mechanism to enforce Section 3 that Congress has provided?
And what's the basis for your opinion that as currently, based on the historical documents, that the Section 3 is, Section 3 is not enforceable absent action from Congress?
Well, my reasoning is this. First of all, as a general matter, the Constitution should not be understood to provide enforcement actions for its provisions directly, sort of taking the naked Section 3, or a case, just two cases from the Supreme Court. The Supremacy Clause, which declares that federal law is Constitution, statutes, acts of Congress, and treaties are supreme law. So in these two Supreme Court cases, the latter of which was from 2015, the court ruled that the Supremacy Clause was not directly enforceable.
And Your Honor, I'm going to object. To the extent he wants to talk about historical sources, that's one thing, but to the extent that he wants to talk about his interpretation of contemporary judicial precedent, I don't think that's proper here.
I think we'll be able to tie it up, but I'm certainly happy to start with a different approach, Your Honor.
Okay, because I tend to agree with Mr. Murray, so I'm going to sustain that objection.
Okay. Looking at the historical record, I believe that you referred at one point in your report to and as has Professor Magliocca, the Griffin's case.
Yeah.
Okay. Could you explain how that's relevant to the self or non-self-executing nature of the 14th Amendment, Section 3?
Section 3. Well, the Griffin case is decided not so long after the 14th Amendment, including Section 3, is ratified. And I think it helps us to understand what, in the mind of the framers and ratifiers, of voters generally, Section 3 was understood to mean. And it's an opinion by the Chief Justice of the United States, Samuel Chase, that addresses the question of whether Section 3 can be directly enforceable without implementing legislation, or whether implementing legislation is required. That's one of the three bases of Chase's opinion. And Chase was not only the chief, it's not an opinion for the Supreme Court, it's an opinion by Chief Justice Chase, writing circuit. But it's soon after the Section 3 is ratified and put into the Constitution, and it's by someone who was not only Chief Justice, but a very fine lawyer and a politician and potential candidate for the presidency at that time. And it's soon after the ratification of Section 3. So I think it's weighty authority as to what Section 3 does and does not do in the absence of action by Congress under Section 5, the enforcement provision of the 14th Amendment. And Chase holds that it's one of his three holdings that Section 3 is not directly judicially enforceable. And that strikes me as very powerful evidence. I'm not saying it's a binding precedent. I mean, for one thing, it's by a justice of the Supreme Court alone. It's not a decision of the Supreme Court. But it strikes me as very powerful evidence as to the original public understanding of what Section 3 did. And there was consideration given in Congress even before Chase's opinion in Griffin's case. There was consideration about the need to enforce Section 3 by acting under Section 5. And that ripened into the enactment in 1870, after Chase's opinion, the enactment of the Enforcement Act of 1870. So Congress took the signal from Chase that Section 3 needed enforcement. There were other reasons, even before Chase, to think that it needed enforcement, and Thaddeus Stevens, who was the departing Speaker of the House, told the House it needed to step up to the plate and enforce, provide legislative mechanisms to enforce Section 3. But it is relevant to a question before the court here of whether it can, without congressional action, decide whether to reach the merits or whether it needs some congressional action before it does it. This applies to both state and federal courts. Now, the Worthy case, I think you mentioned that, and it's certainly pretty prominent in Professor Maglioca's testimony. The Worthy case is a North Carolina case which is decided before Griffin's case, doesn't take account of it, certainly doesn't undercut Chase's opinion, because it's the Worthy case is decided in January of 1869. Chase's opinion comes down in late July of 1869. If I were a judge in North Carolina and knew of and had studied Chase's opinion in Griffin's case, I would have discussed it, in my opinion, in Worthy. Had Worthy come, say, 6 months after Griffin's case, I would certainly have taken account, positively or negatively, but I would have taken account of what the Chief Justice of the United States had said in Griffin.
What was the Worthy case about? Was that actually a direct interpretation of the U.S. Constitution?
Well, as I read it, the court, the North Carolina court, is acting under a North Carolina statute that incorporates and makes state law qualifications based on Section 3. It's not direct enforcement of Section 3 per se. It's enforcement of a state statute that takes Section 3, incorporates it, and applies it to state officials and state offices, which, of course, a state can do. A state can rule on the qualifications or disabilities or whatever of its own state government officials. That it can do. And I think that's what North Carolina did, or was attempting to do. So as to whether globally Section 3 per se is self-enforcing, I don't think Worthy has much, or I don't think it has any real relevance.
Okay.
If you parse out that case closely, I think you see it's acting under North Carolina statute.
Now, shortly after Chief Justice Chase issued a decision in the Griffiths case with respect to the self-executing nature, he also ruled in another case, a second Griffiths case that was, I believe Professor Maglioca and others have stated contradicts his earlier viewpoint on, or his earlier ruling on self-execution. Can you address that, please?
Yeah, the argument that Professor Maglioca and others make is that Chase took inconsistent positions on the enforceability of Section 3 in the Jefferson Davis case from what he said in Griffin's case. First of all, I would say it's not absolutely clear what Chase said or wrote in the Jefferson Davis case. That's a dispute among scholars, but I'm going to assume that he was of the view and that in the Jefferson Davis case, Section 3 was not self-executing. So let's posit that there was a contradiction between Chase in Jefferson Davis and Chase in Griffin. Let's posit that. I don't think that matters, because judges, professors can change their minds, and maybe he did. But the real thing to look at is the quality of his judicial reasoning in Griffin's case. We don't really have an account of any judicial reasoning he may or may not have had in Jefferson Davis's case. So we do have this leading authority in Griffin's case by the Chief Justice. If he's trapped in some kind of contradiction, does that really matter? Look at the quality of the reasoning in Griffin's case. But in any event, even if we do catch Chase in some kind of opposition, contradiction, I think, even if we think we have, I would say that the two cases are reconcilable because Jefferson Davis's legal counsel appeared to have been threatening to use Section 3 as a defense in Jefferson Davis's, it never happened, but in his forthcoming trial on violating the federal treason statute. So that would have been a defensive use of Section 3. And maybe Section 3 can be used defensively against a charge of criminal treason. I'm just not sure about that. We don't have any ruling because what happened with Jefferson Davis was that President Johnson pardoned him and that short-circuited any trial. It just didn't occur. It never happened. Pardoned him from the charge of having committed the federal crime of treason. So Davis's lawyers said that they were planning to use Section 3 as a shield defensively to they sort of thought that Section 3 had displaced or overcome the treason statute in his respect. Whereas in Griffin, Chase was really saying that Section 3 could not independently, directly be used as a sword on which to base a claim to affirmative relief. And the plaintiff, he was a prisoner, was seeking federal habeas relief, so affirmative relief, based on Section 3. That would be using Section 3 as a sword. And Chase reasoned it's not self-executing in that sense. And that opinion, Chase's opinion in Griffin's case, was cited affirmatively, and even the sword shield distinction in it was approved of in a 1979 Fourth Circuit opinion. So Chase's view about the way in which Section 3 was non-self-executing, Chase's view was considered good law until, at least until 1979. I think it's good law, but so what? But certainly in the minds of federal courts, it was good law as late as 1979. That case is called Cole versus City of Covington.
Okay. Did you come across any historical documents or analysis that leads you to conclude that Congress embraced Chase's interpretation of Section?
I think so. The question of whether various iterations of Section 3 would be self-enforcing or not came before Congress actually pretty early in the process of ratifying Section 3. Thaddeus Stevens, who was kind of the leader in the House of the radical Republicans, said the version of Section 3 he preferred would need congressional implementation, He reiterated that when leaving Congress in 1868. There's that. But after Chase, now, to my knowledge, there's no mention explicitly of Griffin in Congress after it came down. But I think it's reasonably safe to assume that Congress, after 1869, was aware of an opinion of the Chief Justice of the United States. Much more likely that they knew of in Griffin's case than they knew of Worthy's case. After that, Congress decided, yes, we will enact implementing legislation that is kind of reinforces Chase's view, because it provided in the Enforcement Act of 1870 a mechanism by which a federal district attorney could, in certain cases, bring Section 3 cases against in court against certain covered officials. They accepted senators and members of the House, but against another class of officials, the federal district attorney was authorized by this federal statute to bring enforcement actions in federal courts alone. So that was how, as I see it, Congress responded to Chase, even though, to my knowledge, it didn't explicitly, nobody in the debates that I've seen explicitly referred to Griffin.
So your view is that congressional enactment, the Congress enacted implementing legislation for Section 3.
Pretty soon after, yeah.
And so, sort of based on your approach to this historical analysis, your view is that they knew about the Griffin's case, or were likely to have known about it?
Yes.
And why is that?
Well, it's an opinion by the Chief Justice.
Okay.
So under this theory, essentially, wouldn't it put the question of whether this provision of the 14th Amendment is even exists, right? I mean, on Congress. So, I mean, it's essentially giving Congress the power to decide what amendments to apply or not apply.
Well, if they're going to be applied...
Could you please move...
Sorry, I'm so sorry.
I'm sorry.
If they're going to be applied as sorts to seek affirmative relief, I think this action, it doesn't originate with, this congressional interest doesn't originate with Griffin's case, but it maybe is prompted by Griffin's case, and it, I think, corroborates or reinforces Chase's conclusion that Section 3 is not self-executing, is used in that way.
My question was just a little bit different,
okay.
Which is if the only way to enforce a constitutional provision such as this is through legislation, then essentially isn't it leaving to Congress to decide whether or not the prohibition exists at all?
Yes. I mean, unless you try to implement it in the way North Carolina did through a state statute that incorporates Section 3 by reference. But I really want to be responsive to your question, Your Honor. But yes, I mean, and in fact, I think Stevens at the time basically was saying, I mean, even earlier than Chase, Thaddeus Stevens was saying, hey, Section 3 is a dead letter. It's a dead letter unless we provide some enforcement mechanism. And, you know, generally speaking, Congress at the time wanted to take charge of the Reconstruction program. And so I think people like Stevens were saying, we want to decide how and when and whether to enforce Section 3 or leave it to be a dead letter. Obviously, Stevens thought that that was a very poor idea, but that's what he was saying. He was warning his colleagues, we can't let this stay a dead letter. And so in the Enforcement Act of 1870, they basically said, we're going to leave it a dead letter, at least for now, as applied to people like us, members of Congress. But we're going to make it a live letter when applied to another group of people who aren't in Congress. There was that threat that it would be a dead letter and not judicially enforceable.
In your opinion is today it's a dead letter? It's essentially...
No. My opinion is that it is not judicially enforceable absent either incorporation as applied to state officials, which is what North Carolina did, or it's not enforceable offensively without an act of Congress, without implementing legislation.
So if Colorado had a statute that adopted Section 3 of the 14th Amendment, is your opinion that then it would be enforceable?
It would be enforceable in Colorado as applied to state officials, candidates, state offices. Outside of that, I think it's not applicable by state law of Colorado.
So at a federal level, your opinion is that Section 3 of the 14th Amendment is a dead letter, essentially, a non-existent constitutional provision because there's no way to enforce it?
Well, no, I don't think it's a total dead letter. We don't know whether it could have been used defensively, as Jefferson Davis tried to do, or not. But it, like much of the 14th Amendment, it requires congressional action to provide the cause of action in a court. There's just this. Can I? Sorry.
Go ahead. I'm just trying to make sure
the baseline under
Professor Delahunty, I'm going to ask you to wait until the sirens go by.
Oh, okay.
That's one of the unique characteristics of this courtroom.
Okay. May I proceed?
Yes.
So the baseline for understanding the Constitution globally is set by the Supreme Court in these Supremacy Clause cases that I mentioned earlier. That's the default position. The Constitution generally, globally, whether it's Section 3 or the Supremacy Clause, the Constitution is not self-enforcing in the relevant sense. And the court in the latter of these two cases, the Armstrong case, explains why the Constitution is not automatically self-enforcing, why it needs guidance. And that is because Congress has to set the policy of the United States and can decide whether and how far to enforce constitutional provisions and whether or not to. That's the general assumption. The Constitution, as a general matter, is not self-enforcing. So that's the Armstrong case.
Your Honor, may I continue, or do you have?
No, of course. I'm sorry to interrupt.
So let me ask you about historical examples of Congress refusing to seat members for whether viewed as treasonous or rebellious or types of behavior that would fall under the ambit of Section 3. Are those examples of congressional enforcement of Section 3?
Well, I don't think they are, because if I recollect that part of Professor Maglioka's report, these two exclusions occurred before Section 3 was ratified, so in that way they're not. Congress has the power to exclude members elect, and that power is a limited one under Powell versus McCormick, but maybe in this relevant period close to the ratification of Section 3, Congress took a broad view of its powers to exclude members-elect and acted under the provisions in Article 1 rather than the 14th Amendment, enabling it to exclude members-elect.
Okay.
For good cause. Now, that's been tightened, the exclusionary powers of Congress. We don't know. The Supreme Court in Powell versus McCormick specifically withheld opining on the question whether Section 3 is a disqualification and a basis for congressional exclusion. It withheld that judgment.
Okay. Let me excuse me one moment, Your Honor. I just need to look at something. Let me move on to I'm just double checking my notes here. Were you able to identify any instances in the historical record of your view where Section 3 was enforced by state officials in state courts? Not a state incorporation into state statute of Section 3 standards, but Section 3 itself directly enforced by state courts.
No.
Okay. Okay. Let's move on to the third item that you had discussed in your report, in your opinion, with respect to an officer of the United States. Mm-hmm. Although before we move there, is there anything else that serves as the basis for your opinion that Section 3 is not self-executing?
Well, I've given the basic reasons, including the Fourth Circuit's reference to and reliance on Chase and application of the schema, the framework of Chase, to the case before it, which was a wrongful discharge action based on an assumed cause of action directly under the 14th Amendment.
Okay. Let's talk about the phrase officer of the United States.
I'm sorry.
Let me ask a question, and then we'll head there. So, what's your response or your opinion on Professor Magliocca's conclusions that the phrase "officer of the United States," as used in Section 3, includes the President and Vice President of the United States?
Well, I disagree with that conclusion. And the more I looked into that question, the more I was persuaded that he is really wrong. I think that term is, in essence, a term of art and had a specialized meaning. And this leads me back to the question of whether I had consulted legal dictionaries, like dictionaries, like Noah Webster on the meaning of insurrection. There is a legal concordance. Now, is that a dictionary? It looks like a dictionary. It's from 1883, I think, by John Lawler. And it offers legal definitions of various terms, including the term officer, and it cites supporting case law for its definition. That definition of officer has a separate, compartmentalized understanding, definition of officer of the United States. Okay, now this is 1883. It's later than the ratification of Section 3, but it's not too long after the conclusion of the Reconstruction period, which is commonly dated to 1876, the election of President Hayes. And so I think it's fair to say that officer of the United States was understood by the legal community, the kind of people who would have read this concordance, looked up the definitions of office. I think it's fair to say that officer of the United States was understood to be a special term needing separate definition from officer generally.
And so what sources, other sources did you look to define what officer of the United States means?
Well, there is the language, the text of the Constitution itself, and then there are a long variety of Supreme Court opinions, going up to a fairly recent one by Chief Justice John Roberts, defining what officer of the United States means for purposes of the Appointments Clause in Section 2. Some of these Appointments Clause cases are roughly around the time of the ratification of Section 3, and they include lower court federal cases about the definition of the term officer of the United States. And of course, it or very close cognates to it appear in the text of the Constitution itself. And so far as possible, one wants to construe these constitutional uses of the term officer of the United States to be consistent, to be the same. So the text of the Constitution uses the term in several contexts, and the meaning should, by ordinary rules of construction, be consistent from one such provision to the next. So I think both the text of the Constitution, especially if you assume this rule of consistent meaning in different uses, the text of the Constitution and the Supreme Court case law support the view, strongly support the view, that the term officer of the United States means the same thing in Section 3 as it means under the Appointments Clause. The Appointments Clause is kind of the anchorage, if I may speak that way, of interpreting the meaning of this phrase, officer of the United States, elsewhere in the Constitution, outside the Appointments Clause, including Section 3.
And why is it considered the anchorage?
Well, because of the principle, because the case law, Supreme Court case law, some of it very recent, but also because if the term is to be used in a consistent way through the text of the Constitution, then it's got to mean elsewhere what it means under the Appointments Clause.
Now, did you also look at the impeachment clause and the drafting documents involving the drafting of the impeachment clause as part of your opinion?
I don't know that I looked directly. I mean, I didn't look closely anyway at the document. Other than as cited in court opinions, I don't think I looked at the original pre-1788 documents. No. Did I look at the case law? Yes. And the case law, I did consult secondary sources about the process of drafting the impeachment clauses, and the secondary sources show, I think, that as used in those clauses, the officer of the United States had a meaning that was designed to exclude the president. There's separate rules about presidential impeachments from impeachments of lower executive level officials and federal judicial officials. There's a separate treatment of those officials in the impeachment clause. Clauses.
Okay. Let me. You also talked a bit about the, with respect to the jurisdictional language of Section 3 involving the oath clause. I'm sorry, we've talked about that in Article 6. Are there any other documents or bases of your opinion that an officer of the United States excludes the president and vice president?
Well, I think the language that the Constitution uses for prescribing an Article 6 oath is strikingly different from the language the Constitution uses in prescribing a quite separate presidential oath in Article 2 of the Constitution. There are two oath clauses, an Article 6.1 and an Article 2.1, okay? And the Section 3 of the 14th Amendment echoes the oath language of Article 6, where those who are subject to it have to take an oath to support the Constitution. If you go back to Section 3 from the oath clause in Section 6, it appears quite obvious to me that they were talking about the class of people who had to take the Article 6 oath, not the people who were talking, that they didn't mean to include the Article 2 oath clause. I think that's, now, Professor Maglioka says that, and he cites a grand jury charge from the 19th century that allows for some play in the joints as to what it means to take an oath to support the Constitution. There can be, his historical source says, some play in the joints, some elasticity. But so what? That doesn't assimilate the Article 6 language, where the president has to swear to preserve, protect, and whatever else it says, the Constitution. You can't just assimilate the language of the Article 2 oath clause into the language of the Article 6 oath clause. That's beyond play in the joints. It's a separate language about how what the president's constitutional responsibilities are.
Now, how do you respond, and I believe Professor Maglioka said, look, an oath to protect and defend is essentially an oath to support, so they're effectively the same thing.
Well, I think that's stretching the language much too far. I mean, people who draft constitutional language have to be very, very careful about the terms they use, especially if those terms are embedded elsewhere in the text of the Constitution. So I think he's going way too far. I once at OLC was tasked with trying to draft an amendment to the Constitution, and we gave up in the end. It was so hard.
And what's the basis for your opinion that people who draft constitutional provisions are very, very careful about the language they use?
What's the basis for my opinion?
Yes, and if you could explain to me the basis in the microphone, that would be great.
Yes. Well, look, there's a principle that Professor Akhil Amar discusses at length in an article called, I think, intertextuality or maybe intratextuality, where he shows that you should, if you are asked to, interpret the same term in different occurrences in the Constitution in the same consistent way.
And Your Honor, I'm just going to object to the extent that we're talking about canons of construction among modern scholars as opposed to historical sources.
Sustained.
Okay. So let me ask you, did, as a matter of historical analysis and knowledge, did the people who drafted Amendment 14, did they take care about the language they used and understand when they used language that mimicked other language or was different than other language? Let me try.
Well, the drafting of section,
Why don't you ask him?
That was a terrible question I was about to say.
Alan, this is Jane, your own.
I mean, it took,
No, I'm not objecting to my question, Your Honor. I'm simply withdrawing it. So, in using the term officer of the United States, or using an oath to support versus a different type of oath, the care and usage of language, did the framers of the 14th Amendment pay conscious attention to the very specific words they were using and how that did or did not reflect other usage in other parts of the Constitution?
well, the initiative to draft a new amendment to the Constitution came very early after the Civil War, because it was considered generally, widely, that there was need to bring the Constitution up to date, and in particular a need to get rid of Dred Scott and its holding on citizenship. So the Congress, very, very early in its term, set up a 15-member joint committee, including members of the House and Senate, to do exactly that. They included some very fine lawyers and very thoughtful people, and the committee considered several draft versions of what later matures into the 14th Amendment, including Section 3. And those proposals, which ripened over months by leading members of both houses, then are presented to the House and Senate for consideration, again by very able lawyers. And do I have proof that somebody sat down one day in the course of these deliberations and said, we got to make sure that everything clicks into place? No. Do I make the assumption based on the care and length of the deliberations that the select committee and houses gave, and the attention that was given to it to determine exactly who was covered, who was jurisdictionally subject? Do I make the assumption that that was given careful consideration to bring it into line with the rest of the Constitution, or else depart from the standard meaning? Yes, that is an assumption I would make.
I have no further questions. Your Honor, if you have any further questions, we're certainly appreciate the discourse that you may have.
I was just wondering, Professor Mendoza, he showed us some discussion about the enactment of Section 3 of the 14th Amendment, in which one of the senators stated, don't we want to make sure that this applies to the president? And then somebody responded and said, well, it applies in the kind of catch-all phrase. And then the gentleman says, oh yeah, I see, you're right. So how does that discourse, which impact your opinion in this?
That Senate colloquy between Senator Reverdy Johnson of Maryland and Senator, I can never remember whether it's Merrill Lott or Lott Merrill, I think it's Merrill Lott of Maine. That colloquy concerns the disqualification clause of Section 3, not the jurisdictional clause. So it is relevant to interpreting from what offices a covered person who has committed the relevant offense will be excluded. That's the start of the language in Section 3. But it doesn't go to the coverage of the jurisdictional coverage of Section 3. You can't just map on the leading language of Section 3 about from what offices shall this person be excluded onto who is covered by Section 3. It goes more to whether the presidency as an office is included in Section 3, then it goes to the question whether the president is or is not an officer of the United States. So I don't think it's relevant, frankly, to the interpretation of the judicial, the jurisdictional aspect of Section 3.
Thank you, I appreciate that.
Your Honor, we have no further questions, and with that, we will release the witness to opposing counsel for cross, although I know it's about 11:30.
Yeah, so let's just talk for a second about timing. I know that we were planning on having Mr. Heafy at 1. Is that like a hard time, or does Mr. Heafy have some flexibility in his schedule?
Mr. Grimsley can talk about his schedule.
Your Honor, that's a pretty hard time for him. He teaches class in the evening, and he's on the East Coast, so that's 3 o'clock for him, his time. So I think it would be fine with us to take him out of order. Just as much as I don't want to interrupt the cross-examination, I think it would make sense to do so.
And I guess the question for you, Professor Delahunty, is are you available to finish your cross-examination after we take this other witness, or are you available today?
Today, yes.
Okay, it would be today. It just, we may go till noon and then break for lunch to Mr. Heafy and come back to you sometime later in the afternoon. Is that okay with you?
Yes.
Okay. So let's do about a half hour of cross-examination, and if you aren't finished, we'll finish it after Mr. Heafy.
Yes, Your Honor, thank you. Let me just make sure we've got me up on the screens here. Looks like we're on this one, but not this one.
You may proceed.
Good morning, Mr. Delahunty. You're not claiming to be an expert in the history of Section 3 of the 14th Amendment, are you? And certainly Section 3 of the 14th Amendment is not the main focus of your scholarly work, correct?
That's true. It has been for very few academics until recently.
I want to look briefly at some of the things that you have published academic literature on. This is Petitioner's Exhibit 315. Is this your latest CV?
Yes, I think it is. I did ask counsel to submit a slightly updated CV.
Yes, and this is the one we received,
Okay.
I believe, on Wednesday.
Yes,
of this
okay.
week. On page 3 of your CV, we have some articles and book chapters here, and one of those is a book chapter, Deconstructing the Deep State,
Yes.
in the book Up from Conservatism.
Yes,
Do you see
that's
that?
right, yes.
And you've also written on, for example, the major questions doctrine and the administrative state.
Yes.
You mentioned some publications on Shakespeare. Is this one of them here?
Yes.
And at the bottom, there's another one about Shakespeare's King Henry and Just War. Is that right?
Yes.
You have a lot of publications on foreign affairs and international law, such as Toward a Concert of Asia and the Crimean Crisis and the use of weaponized drones. Is that right?
Well, the first one was accepted for publication, and then I think this publication by the university, by a journal at the University of Pennsylvania, was never actually published. It wasn't rejected. I think they just closed down. But yes, in that sense, it was accepted for publication, yes.
And those are things you wrote?
Well, it never got published. I don't know exactly what you mean by it's a big zero, but...
Do you mind just speaking a little bit? Thank you.
I mean, I think I gave full disclosure. It was accepted for publication, but was not published. Does that make it a big zero? I don't understand the question.
Oh, no, I'm sorry. I may have misspoke. But let me ask you another question. Nothing on this page of your CV relates at all to Section 3 of the 14th Amendment.
No, that's certainly true.
And I'm not going to go through every item in your CV, but just on the next page, we do have some additional articles on things like international law, the laws of war, the Bush Doctrine, Latin America. things like that, correct?
Yes.
And again, there's nothing on this page, no publications that relate to Section 3 of the 14th Amendment.
No.
On the next page of your CV, once again, there's articles on international relations, on the Kosovo crisis, on why American and European attitudes towards international law differ, on against foreign law, and things like that, correct?
Yes.
And again, on
Although, if I may say, the piece about against foreign law is about constitutional adjudication and whether foreign law should be imported into the interpretation of constitutional clauses.
Understood. And in your article against foreign law, you weren't discussing Section 3 of the...
No.
Please wait till the end of the question.
So the whole nature of cross-examination is that they're usually yes or no answers, and you kind of know where he's going, so you're tempted to answer before he finishes, but that'll wait just for the court record, okay?
Okay.
And if we go to the next page of your CV, we have a few more articles on things like the Geneva Convention and the President's authority to conduct, constitutional authority to conduct military operations and foreign affairs matters. Is that correct?
Yes.
You've also written on philosophy. For example, you have an article about Descartes, correct?
Yes.
And you've written a book on the philosopher Baruch Spinoza, true?
Yes.
You've never written a book with a central focus on the history of the 14th Amendment, have you?
No.
These days, you write a lot of political commentary, is that right?
Yes.
For example, you write articles and op-eds in Fox News and the National Review and the Federalist.
Yes.
For example, you wrote an article with John Yoo entitled "Pushing Back on Cancel Culture." Do you see that?
Yes.
And on the next page, you have a number of articles about China and COVID, such as how to make China pay for COVID-19, correct?
Yes.
And if we go a few pages down the line, there's articles about things like the South Korean election, the Persian Gambit, and Brexit, correct?
Yes.
Do you remember writing an article in the Federalist this summer about why, in your view, Democrats can't ditch Biden?
Yes.
In that article, you claimed that Biden was suffering from what you called embarrassingly obvious cognitive decline. Is that right?
Yes.
In that article, you said that President Biden is surrounded by the stench of corruption, and you cited evidence from, quote, the Hunter Biden laptop. Do you remember that?
Yes.
In that article, you also discussed, quote, the pouch of cocaine found in Biden's White House. Do you remember that?
Yes.
And in that article, you referred to the Democrats and their deep state enforcers in the FBI and CIA. Do you recall that as well?
Yes.
You've never written a peer-reviewed article with a primary focus on the history of the 14th Amendment. Is that right?
That's right.
You've never published a peer-reviewed article about Section 3 of the 14th Amendment, correct?
No, I have not.
Now, you have published one article talking about Section 3. Is that right?
Yes, an op-ed.
That was an op-ed in the Federalist in August of this year?
That's right.
You'll agree with me that your op-ed in the Federalist was not a work of historical scholarship, right?
That's right.
It doesn't cite very many historical primary sources.
No.
You've never given expert testimony before, correct?
Correct.
I want to ask you a few questions about historical methodology. When you're doing historical work, I think you said on direct that you look at primary sources, correct?
Yes.
And it's always better to go back and look at the original primary sources than it is to take some secondary sources' word for what those primary sources said.
That is correct.
Were any of the sources that you discussed on direct examination, sources that were uncovered through your own original archival research?
No.
In your report, you said that you gave a draft of your report to Professors Blackman and Tillman. Do you recall that?
That's right.
You said that you gave Professors Blackman and Tillman a draft of your report because they have, quote, written extensively on the subjects discussed in my report,
Yes.
right? Unlike you, Blackman and Tillman have written extensively on the subject of whether the President is an officer of the United States under Section 3 of the 14th Amendment.
That is correct.
But you know that not all scholars agree with that view, right?
I do.
You know that Professors William Bode and Michael Paulson disagree with that view?
I certainly do.
Did you ever ask Professors Bode or Paulson to comment on your draft report?
No.
You know that Mark Graber disagrees with the Blackman and Tillman view that the President is not an officer of the United States, right?
Well, I haven't read the Graber piece, but I assume that he is in agreement, or disagreement, rather, with Tillman and Blackman.
You haven't read Mark Graber's piece discussing the history of Section 3 of the 14th Amendment?
No.
And so you never asked Mark Graber to comment on your draft report either?
No.
Did you ever give a draft of your report to John Vlahopoulos?
No.
Do you know who that is?
Yes, I've seen references to his recent work.
He also wrote an entire article responding to the Blackman and Tillman position that the President is not an officer under Section 3, right?
I didn't know that, but yes.
You didn't know about that article, and you didn't read the article where John Vlahopoulos responds directly to the Blackman and Tillman position in the context of Section 3?
No.
You didn't solicit comments from any scholars who disagree with your opinion on whether the President is an officer of the United States? I want to ask you about some of the sources you do rely on. I want to pull up your report, Petitioners Exhibit 227. And does this appear to be the expert report that you served in this case?
Yes.
Do you recall that in your expert report you have, starting on page 5, a background to Section 3 of the 14th Amendment?
Yes.
And if we scroll through, just that section is about 7 pages long, and it goes until page 12 of your report?
Mm-hmm. Yes.
In that entire section, you don't cite a single primary source, do you, sir?
I don't think so, no.
You do cite to Professor Kurt Lash's recent article on Section 3, though, right?
Yeah, yes, yes.
And certainly you don't cite any original historical research that you...
No, not on the background, no.
And in this article by Kurt Lash, that's your only citation in your background section, that's a draft paper that hasn't been published yet,
That's right.
That was actually posted on SSRN just a few weeks ago.
That's right.
I want to look briefly at Professor Lash's draft paper, Petitioners Exhibit 289. Does this appear to be the article from Professor Lash that you relied on?
It does.
If we go to page 3 of Professor Lash's article, there's a footnote here, footnote 5, and it says, a robust scholarly debate has emerged regarding the proper reading of Section 3 terms, such as office and officer, and those who have previously taken an oath as an officer of the United States. Do you see that?
Yes.
And then he cites a number of scholars, right?
Yes.
And some of the scholars he cites are Josh Blackman and Seth Barrett Tillman, who you said you sent your draft report to, right?
Yes.
He also cites William Bode and Michael Paulson, right?
Yes.
And he also cites Mark Graber, whose paper you said you never read, correct?
You mean that particular citation? I have not read his piece in Lawfare, no.
He also cites, as a contributor to this robust scholarly debate, Gerard Magliocca, who you understand is petitioner's expert in this case, who testified earlier this week, correct?
Yes, yes.
Professor Lash does not list you as having made any contributions to the robust scholarly debate about the proper meaning of office and officer under Section 3. Is that right?
That's right.
If we go to page 48, there's another footnote, and it's a long footnote. I'm not going to ask about the substance of what the sources are talking about, but I just want to ask you, do you see in footnote 218, Professor Lash cites an opinion reported in the Times-Picayune
Yes.
and a jury charge
Yes.
reported in the Tennessean?
Yes.
And at the end of that footnote, Professor Lash says, "My thanks to Gerard Magliocca for the pointer to these opinions," correct?
Yes.
Nowhere in Professor Lash's article is there an acknowledgement given to you for any contribution that you've made to the historical record on Section 3, correct?
That is correct.
And in fact, Professor Lash's article doesn't cite you anywhere in his draft article. Is
No,
that right?
he does not.
Your Honor, at this point, we would renew our motion to exclude the testimony under Section 702.
I'm going to deny the motion. As I said, Professor Delahunty has expertise in reviewing historical documents and applying them to constitutional provisions, and his lack of scholarly contribution to Section 3 in particular, I don't think excludes him from testifying on the opinions that he's testified to today.
Thank you, Your Honor. At this point, I'm going to move on to the substance of his opinions, but I know we only have a few minutes left, so I wanted to see if you wanted me to start with that, or if we want to just break for lunch now.
Why don't you start, just since we're running a little bit behind today. We'll go for about 10-15 minutes and maybe take a little bit shorter lunch.
Sure. Mr. Delahunty, I believe you said on direct that the 14th Amendment was, that you begin your constitutional law classes with the 14th Amendment. Is that right?
Yes.
And you called...
Actually, that's probably what I said. I began it with Dred Scott, typically.
Dred Scott, and then a discussion
Correct.
of the 14th Amendment?
Yes.
And you referred to the 14th Amendment as a second founding of
Yes.
our Constitution. Is that right?
Yes.
The 14th Amendment is not some kind of second-class constitutional amendment. You'd agree with that, right?
I do. Although, well, I wouldn't. I don't think you can make it. What is, may I ask for clarification of the question?
You can ask him to repeat the question, but I'm just going to admonish you again to let him finish his questions before you start to answer.
Okay. I don't understand the distinction you're trying to draw, counsel, between first-class and second-class amendments.
Well, I'm not sure I do either. I'm just trying to make the point that there's nothing that says that the 14th Amendment is somehow lesser than any other constitutional amendment.
That's right. They stand on an equal plane.
So I want to start by talking about your opinion that Section 3 is ambiguous and that therefore it needs congressional enforcement legislation. You'd agree with me that courts interpret ambiguous text all the time, right?
Indeed.
Courts interpret unreasonable searches and seizures in the Fourth Amendment, for example.
That's right.
And even in the 14th Amendment, they interpret terms like due process and equal protection, correct?
Yes.
Are you aware of judicial decisions saying that we can't tell what an unreasonable search and seizure is or due process of law is unless Congress tells us?
No, I'm not aware of any such decisions.
When you teach constitutional law, do you teach Marbury v. Madison?
Yes.
And that's a case where the Supreme Court, Chief Justice John Marshall said it's emphatically the province of the judicial branch to say what the law is, right?
It is, yes.
You know that courts interpreted and applied Section 3 pursuant to state law even before Congress enacted implementing legislation.
That is true.
Your opinion, one of your opinions is that it's difficult to understand how the phrase insurrection was defined during Reconstruction, correct?
Well, I don't know that it was defined at all, but it is difficult to interpret the term.
But you agree with petitioners that Section 3 remains in force even outside the context of the Civil War.
I do agree with that. And so state in the report.
And you agree that Section 3 has continuing relevance to any future insurrection or rebellion?
I do agree with that, yes.
You also agree that insurrection need not rise to the level of an organized rebellion.
That is what the Supreme Court says in the Prize cases, and I agree with it.
And the Prize cases were cases that came up during the Civil War where the Supreme Court said just that, right?
Said?
Where the Supreme Court said that an insurrection need not rise to the level of a rebellion.
Yes.
And insurrection also need not rise to the level of a civil war, is that right?
Yes.
You're not saying that a criminal conviction or a guilty plea on a charge of insurrection is a necessary condition for a Section 3 disqualification?
No.
On direct examination, when you were talking about the president's oath versus an oath to support the Constitution, you said that the drafters of the Constitution were very careful with their words. Is that right?
Yes.
Is it your testimony that they were so careful with their words that they used a term, insurrection, that just had no clear meaning?
Can I follow? I don't understand. Could you repeat it?
Well, you testified that the framers were careful with their words.
Yes.
But you've also testified that insurrection is a sufficiently unclear term that we need Congress to tell us what it means. Is that right?
Did I testify to that? I don't remember, but I think I probably did, yes. Certainly that congressional guidance would be helpful, instructive to the courts, because the term is pretty broad-gauged. There's also the question of whether the courts can enforce it at all without Section 5 action, but that's separate, I think, from what you asked me.
Can I just ask you to speak a little
bit? Oh, yes. The question is a bit complicated because it implicates Section 5 of the 14th Amendment as well as Section 3.
And other provisions of the 14th Amendment, like Section 1, also implicate Section 5, right?
Yes.
Now, if I have trouble knowing what a word means, sometimes I go to a dictionary. So let's look at some dictionaries. And this is Petitioner's Exhibit 144, the appendix of materials that we looked at with Professor Magliocca. Page 785, I believe you testified about Webster's on direct, but we didn't look at it. Webster's, in the antebellum period, defined insurrection as a rising against civil or political authority, the open and active opposition of a number of persons to the execution of law in a city or state, correct?
Yes.
And Webster's was not the only dictionary in the antebellum period that defined insurrection in just this way, was it?
I think that Webster's definition is the essence of it, maybe not word for word, particularly execution of the law in a city or state. It was widely accepted, maybe even followed.
You cite some cases in your report as well, and I just want to pull that discussion up. Plaintiff's Exhibit 227 is your report. And if we go to page 71, there's a discussion of a Georgia Supreme Court case in 1868 called Chanceley versus Bailey. Do you see that?
Yes.
And in Chanceley versus Bailey, the year that the 14th Amendment was ratified, the Georgia Supreme Court said, if the late war had been marked merely by armed resistance of some of the citizens of the state to its laws, or to the laws of the federal government, as in the cases of Massachusetts in 1789 and in Pennsylvania in 1793, it would very properly have been called an insurrection, and the acts of such insurgents would have been held as illegal, correct?
Yes.
You also testified on direct about the instructions by Justice Catron that we looked at in Professor Magliocca's testimony, and you called those grand jury instructions helpful in understanding insurrection. Is that right?
Yes.
And just to make sure we're all looking at the same thing, If we go a few pages into 752 of Professor Magliocca's appendix, Justice Catron instructed the jury that the conspiracy and the insurrection connected with it must be to the effect to affect something of a public nature concerning the United States, to overthrow the government or some department thereof, or to nullify and totally hinder the execution of the United States law or Constitution, or some part thereof, or to compel its abrogation, repeal, modification, or change by a resort to violence. That was the instruction that you found helpful, correct?
Yes.
Did you also look at how Justice Chase, not the Chief Justice, the other Justice Chase, defined insurrection in the case of Fries?
No.
If we go to page 834 of Professor Magliocca's appendix, this is case of Fries from the Circuit Court of the District of Pennsylvania in 1800. Do you see that?
Yes.
If we go to page 841, the court says, on this general position, the courts are of the opinion that any such insurrection or rising to resist or prevent by force or violence the execution of any statute of the United States for levying or collecting taxes, duties, imposts, or excises, or for calling forth the militia to execute the laws of the Union, or for any other object of a general nature or national concern under any pretense, as that the statute was unjust, burdensome, oppressive, or unconstitutional, is a levying war against the United States within the contemplation and construction of the Constitution. Correct?
Yes.
And that also uses this language we've seen earlier about a rising up to resist by force or violence the execution of law, correct?
Yes.
I just want to finish this line of questioning by asking about your example where you say that Professor Magliocca's definition of insurrection against the Constitution would essentially mean that Section 3 covers any effort to obstruct the mail. Do you remember that testimony?
Yes.
Well, that's your interpretation. That's not something Professor Magliocca ever testified about, correct?
That's right.
Do you remember that when Professor Magliocca gave his definition of insurrection, his definition was a group of persons resisting execution of law by force or threat of force?
Yes.
And do you also recall that Professor Magliocca explained that Section 3 only applies to those who had previously sworn an oath in certain kinds of official capacities?
That was my recollection of his testimony, yes.
If a person has never been in government and never taken an oath to the Constitution, does Section 3 have anything to do with them at all?
Well, that's a requirement under the offense element, who, having taken an oath to support the Constitution, thereafter engaged in some kind of activities.
All right, Your Honor, I think this would be a good time to break for lunch.
Agreed. We will reconvene at 1 o'clock for Mr. Heafy, and then we will finish your testimony, Professor Delonte, after Mr. Heafy is done, okay?
May I have lunch and speak with my counsel?
You may absolutely have lunch.
But not discuss my testimony?
Under the rules, you're not supposed to discuss your testimony with counsel.
Okay, thank you.
But
thank you.
we do want you to eat.
Thank you.
Okay.